Well, thank you very much. It's a great pleasure to be asked to moderate the session about trusts and foundations. I'm a partner in the law firm Charles Russell Speechlys. I joined recently, and before that I was head of international wealth structuring for Barclays Wealth. So in that context I came to Nigeria on a number of occasions to work with the bankers, and it's been a real delight joining Charles Russell Speechlys because my partner Adrian Mayer has established a very good African business focused on corporate transactions. So my private client partner Oliver Little and myself were asked to join Adrian to focus on Africa, which plays quite strongly to my experience with Barclays. I suppose in that context, if I look back on my time at Barclays, unsurprisingly, trusts and foundations figured pretty heavily in a wealth advisory business. So what initial conclusions would I draw from those experiences I had? The first one I would say is that the difference between the two can be quite stark. So as we'll discuss amongst my learned colleagues, the choice between having a trust and a foundation is actually quite nuanced. In particular, a foundation is a separate legal entity and a trust is not. If you look back over the history of the last 20 years, it's quite clear that the common law jurisdictions have made an enormous effort to incorporate the traditional Liechtenstein concept of a foundation under their own jurisdictions. So there's been an enormous proliferation of foundations, and Lorna, I'll ask you to comment on that from a Mauritian perspective. Just one or two points about asset protection, as that's one of the themes of this conference. I think one critically important point when establishing any structure is what is the point of this structure and what are the risks? Because I've often seen structures put in place without actually contemplating what might happen or what the point of the structure is. Asset protection I always view as being quite a separate subject that needs quite careful consideration. Some offshore jurisdictions, for example, have specific asset protection rules which, unsurprisingly, purport to protect the assets from the claim of creditors. So it's really important to crystallise that issue. I'll give you one or two examples in terms of what I have seen go wrong. I mean, the first one is my observation of working with Barclays here in Lagos is that a lot of trusts were sold rather than thoughtfully created. Not that that is any enormous surprise, but for example, one of the most popular trusts here was the so-called, or is the so-called, Reserve Power Trust, which does what it says on the tin. In other words, the settlor has reserved all the powers and calls all the shots whilst enjoying the merits of having a trust. I mean, to be honest, the bank quite liked that because the bank took no risk and the settlor took all the risk. But at another level, is that a good structure from an asset protection perspective? The answer is no, it's not. And the reason is that the power of revoking the trust can fall into the hands of a trustee in bankruptcy, as happened in TMSF versus Merrill Lynch, where the Turkish government was able to recover the assets from the trust by exercising the power of revocation that the settlor had. So that's one example. Another example we frequently see is, dare I say it, failure to anticipate gruesome divorces. We have a strong family team at Charles Russell Speechlys, and we do a lot of international divorce work, which almost invariably involves international foundations and trusts. And the key question there is that structure going to actually be invulnerable in the event of an attack? Because all too often it isn't, and the reason it isn't is that the people running the trust or foundation have either inadvertently strayed into the jurisdiction or committed another arch sin, which is lack of substance, which I'll come on to discuss, I think, with Bimpe. The final point I want to make is the other thing to be aware of is sometimes structures can be too good at protecting assets, and that's something to really watch. One of the bigger cases I had was based around a Liechtenstein foundation, which had worked very well while the patriarch was alive, but when the patriarch died, the beneficiaries, and I use that in the loosest possible sense of the word in this case, because it turned out the real beneficiaries were the council members running the foundation and not the patriarch's family. And what we found was that there was a difficulty in terms of opaque structure, lack of information, and most importantly of all, lack of recourse, no accountability, no responsibility. So that was a very unsatisfactory experience, especially from a litigation perspective. But we don't really want to talk too much about litigation, but I just wanted to highlight the importance of these structures. If asset protection is a concern, then that's got to be addressed right from the off. But Lorna, with your experience in Mauritius, I was going to ask you to take us through your views on trust versus foundations there, and where you see one offering more flexibility than the other in terms of the wealth owner's involvement.
Thank you, Jonathan. So I think taking a little bit of what we learned yesterday is that there is no one-fit-all structure. And the name that came back was like fit for purpose. So you really need to decide what is the purpose of you creating a vehicle, the timing, the familiarity of the structure, and also having the confidence that this is the right structure for you, for your family, and the generation to come. So if in terms of the flexibility of a trust versus a foundation, especially in that particular case where there is a certain requirement to retain control and to ensure succession planning, foundation is usually a sophisticated, flexible, and tax-efficient structure for both wealth distribution and preservation. So from a Mauritius perspective, we have seen a lot of foundation being created for this particular advantage or for this particular purpose. So the foundation has a specific attraction that it could be seen as a hybrid between a trust and a corporate legal entity. So it has some features that both benefits from a trust and slightly from a corporate entity, in that in a foundation, it is a separate legal entity, as Jonathan rightly mentioned, similar to a company, with the founder vesting its asset just like he will do in a trust, but he will have a council of members that will actually take the decision to ensure that this is properly managed in the same way that a board of a director will be looking after a corporate entity. So for a foundation, it ensures asset protection. So in that case, being a legal entity, it enables you to safeguard your asset from any personal claims, for example. It also gives you the control and flexibility where the founders, as part of the council members, can continue to guide and put the relevant governance in place for the smooth running of the foundation. And of course, it ensures succession planning. In terms of the beneficiaries, it also enables the confidentiality that your assets are safeguarded in the right way. Within Mauritius, we have the Strong Foundation Act. So the foundation will be operating within a legal, structured legal system, and it is quite tax efficient. So I think in my purview, Jonathan, foundation enables a convenient way to pass control and influence of the family members' interests and wealth to the next generation, but by ensuring family participation and also the empowerment of the children so that it can exist for a number of years. So from my sense, in that way, foundation can have a better leverage like over a simple trust structure. Thank you.
Well, that's quite interesting. And again, casting my mind back to Barclay's days when I travel a lot in Africa and the Middle East, foundations were really coming on the radar screen because Jersey had created foundations, and I quickly realized that certainly in the Middle East, it was a more compelling thing to talk about than trusts, because a lot of people struggled with the idea of, would you like to hand over your assets to this gentleman in a suit? Because in those days, bankers wore suits, and it wasn't an enormously compelling proposition on the face of it. But with foundations, because they were more like companies, they were much more readily understood by, guess what, people who run companies. So I used to say to these people, I have to say that they tended to be gentlemen, but I said, you must know how to run a company. And they usually brightened up and said, yes, I'm running 170. So I said, well, the foundation's more like a company, but we need a chairman of this foundation, and who better than yourself? Because you've proved to be a very adept chairman. So there's normally a meeting of minds. And of course, that was one major selling point for the foundation, is it is much more proximate to the levers of control, because the council members can consist of the wealth owner, the business owner, his family members, and other advisors. I have to say the stumbling block with the Jersey Foundation at the time was Jersey insist on having a qualified person on the board. So if you were, for example, using the old Barclays Trust Company Zedra, you would have to have someone from Zedra on the board of a Jersey Foundation, and that did make people and I mean, fascinatingly, if that's quite the right word, when Guernsey came up with their foundation rules, they didn't have to have a qualified person on the board. But that brings us around to something I want to ask Bimpe, which is about the importance of having substance in structures. And I personally think it's become super important. It's no good anymore having people who are literally asleep at the wheel of your structure. I remember meeting a very wealthy person whose structure was somewhat moribund, and I said to him, look, you're in the UK, you have got to have some smoke coming out of this chimney. So as a result, we were able to get some fire going to put smoke up the chimney by involving a very good firm of professional trustees to run the structure. But Bimpe, I was just going to ask, what's your experience with involving professionals in a family's trust structure or on the board of the foundation? What do you think the pros and cons are?
Thanks, Jonathan. I think, just to give a bit of context, just back, going back to what Lorna was saying, what I've seen over the years is that I would say our current generation of Nigerian families, some of whom are beneficiaries of trusts that were set up by a patriarch who sometimes has since passed, like you said, struggle with the idea of actually, these trustees in Jersey or Guernsey or, Luxembourg or where have you, are the ones who are taking decisions, and a lot of times they haven't even met the family members. They only knew the patriarch or know the patriarch. And yes, even if he's reserved powers, they're dealing with him when he's alive, that's fine. But once he's gone, I find that in those trust structures, there's been no interaction between, the trustees and the family. Now, a foundation gives that element of really bringing in the discussion and communication across the board with the professional person. And I think even if it's not prescribed to have a professional person, a fiduciary, an expert, someone either with a legal and fiduciary background, I would say it's important. And usually, take Mauritius for example, I think it is sort of mandatory, isn't it, to have someone from the company that is providing, the trust company that's providing the structure, because structure, by nature of its address, is sitting with a Mauritius trust company like IQEQ, and by nature of the fact that they're regulated and they want to make sure that they have full oversight on whatever it is foundation is holding or doing, they insist that somebody must sit on the council from their side, and they also will act in an advisory capacity when needed. However, I think it's also important that the family then, and I say to families, let's around this table we can include your local advisor, your lawyer in Nigeria, or trusted advisor, or your asset manager or private banker with whom you have a relationship, who knows the patriarch, knows the children, and understands the dynamic going on. I often sit on many family councils as well for that same reason. But the other thing is that it's important that the family council includes the wealth owners. So the patriarch and matriarch set up the foundation. They usually are protectors, which means that some power is still rests with them. But the actual day-to-day operational things are carried out by the council. But there's a check and balance, because what you're doing is by involving professionals, by involving the compliance mechanism via, say, the trust company, and involving the children, the owners of the wealth itself, the conversation becomes much more balanced. They're taking advice, and they have to heed the advice, especially where the compliance issue is concerned. But at least it gives that family the start of a governance mechanism, because that council, the charter governing the council, becomes the family charter, the family constitution that the beneficiaries also have to adhere to.
And maybe, Bimpe, if I can add as well, is that the foundation also gives you the ability of appointing a wealth manager, like a portfolio manager, that not necessarily needs to sit in Mauritius. It can be your international portfolio manager that can help with regards to the wealth management side of any funds hiding at the level of the foundation. So this gives you a little bit of more broader trusted advisors that you can pull and bring to the foundation as part of your decision making.
Can I just say something? Something just crossed my mind. I think just to have clear the air, first of all, when we say foundation, we're not referring to a not-for-profit. We're not referring to a philanthropic entity. We're referring to a private foundation. So often in my communications, I'll say to a client, this is what a private foundation will do, because I know in the minds of most people, a foundation means a charity. And this foundation could also be, be actually part of the governing body of the family's charity. But we're talking here now about a private foundation that does not have any philanthropic objectives at all. Just to be clear.
No, well, thank you for that clarity. But certainly picking up something you said there, Bimpe, the importance of balance in the structure, and in particular with trusts, the use of protectors or protector committees, or in the case of foundations, guardians, I think is a developing area. It's certainly a developing area in case law, because there have been recent cases about the scope of the powers of protectors. And to my amazement, there's a narrower view where if the protector is asked to consent something the trustees are doing, he should just check that it's a valid exercise of the trustees' powers, versus the wider view, which is that the protector should be forming an independent assessment of whether the trustees' proposed distribution is in the interest of the beneficiaries and acting like that. So if anyone is setting up a trust, they are quite likely to be asked to form a view on the scope of the protector powers. I suppose the other point on protectors is there is sometimes a case of who watches the watchers, because people often say, who appoints the protector, and then who can remove the protector, and who can remove the appointer. So you can get into a sort of doom loop of trying to imagine this endless list of people that some people want to be watching over things. It really is, as far as trusts are concerned, what it says on the tin. I always say to clients, as a trust suggests, if you're going to set up a trust, you are going to have to trust someone. And that's the fundamental point, and that's where it stops. Who do you trust? And really, in a way, if you can't trust anyone, then you might be better off not having a trust. But I'm going to ask my esteemed former colleague, Morag, what about tax? Because we often see tax coming up. There were some excellent questions in the last session about family offices about things like, structures getting mixed up with dual citizens like Americans, or in this case, foundations getting mixed up with other jurisdictions. Can you just take us through that?
Yeah, thank you very much, Jonathan. I just wanted to pick up on your point about, who do you trust, and if you don't trust anyone, don't create a trust structure. I think it's really important because a lot of people see trusts as a legal entity. They're not legal entities, they're relationships. And it's a relationship built on trust. You're effectively splitting up the legal ownership of an asset, and you're handing it to someone who you trust and saying, I trust you to manage this asset in a way that is in the best interest of the beneficiaries. And in my own personal experience, I do feel that sometimes the concept of trust is hard for Nigerians. Many people don't trust members of their own family, or they've been disappointed by business associates. And I remember as a child, we used to drive to the village, and it always surprised me that people used to write on the side of their house, do not trust my brother, this house is not for sale. So, we've got a long way to go to get to a level of complete trust with this type of structure. But I just wanted to say at the outset, it is a relationship. And so you have to be comfortable with that relationship before you hand over your assets and your significant wealth.
Yeah, I just think, just on that, I think the hardest word for a trustee to say is the word no. And really, the distinction of the best trustees that I've come across is the ability to say no when they have to say no. And that's something I often go through with settlors of trust right from the very outset, because it's really important that they understand that one day circumstances may dictate that the right answer is no. because a survey of trust litigation cases shows that a misunderstanding on that point is perhaps the biggest generator of discontent and disputes. But that's a slightly circuitous way to ask you about tax, Morag.
I know. Well, I feel like I scared a lot of people with the UK tax yesterday, so I thought I'd start with a light-hearted story instead. So from a UK perspective, it's important to know that the UK doesn't really recognise foundations. Foundations are broadly a construct of civil law jurisdictions, and the UK is a common law jurisdiction. So there is a lot of uncertainty from a tax perspective in respect of foundations. Lorna was completely right. They are a hybrid of trust and company, and within the UK tax statute, there isn't specific provisions on how to tax a foundation. So what HMRC do is they look at the constitutional documents and they just do a smell test. And they say, does this smell like a trust or does it smell more like a foundation? So like a company. And if they feel like it has the hallmarks of a company, then they will tax it as a company. If they feel like it has the hallmarks more of a trust, then it will be taxed as a trust. So it's not as simple as simply saying, I have a foundation and that's the end of that conversation. I get the benefits of the corporate taxation structure. You really have to work closely with your advisors to ensure that the constitutional documents achieve the aims that you want them to achieve. So broadly, I'm going to talk a little bit about how trusts are taxed in the UK, and I'll defer to Jonathan because he is well more learned than I on this topic, and then quickly in respect of foundations. So in terms of trusts, I think a lot of people don't really understand that there are multiple layers of taxation in a trust. They are commonly seen as a tax-efficient structure, and for a very long time they were. I think from a UK perspective, some of those tax efficiencies have left or are misunderstood. If you are the settlor of a trust, you may have to pay an entry charge to settle the assets. If you retain an interest in the trust assets, you may be subject to income tax and capital gains. If you have UK resident beneficiaries who receive distributions from the trust, those distributions will be taxable in the UK. If you exit assets from the trust, they will be subject to exit charges. And trusts generally have 10-year anniversary charges where HMRC just taxes them every 10 years because they've been around for so long. So it's important to understand the financial cost of setting up a trust. I think a lot of people think it's the right structure for them because they've been around for a long time and they've heard about them. But I think that's why it's really important to understand that there are other options available, especially when, as all the other panelists have discussed, you're dealing with issues of control. A lot of people do not want to give up control of their assets. A lot of people do not trust a third party to make the decisions that they want to make. And so in that regard, foundations are a much more preferable option. In terms of the taxation of a foundation, because it works slightly more akin to a company, if your constitutional documents allow it to work like a company, you can have income and gains accumulate within the entity, and so you would only be taxed on the distribution rather than on an ongoing arising basis. And so there can be benefits to that from a longer-term planning perspective, from an investment perspective, from an incentivizing family members who work in the business perspective, and that can all be managed and controlled through the constitutional document.
Yes, that's interesting. I suppose, just to mention from experience, that the USA also doesn't recognise a foundation, so unsurprisingly, the IRS tends to characterise them in the manner that would produce the most tax for the IRS. So that's another observation on that.
Can I just say something? I mean, and I know, you know, when we use the word recognize in the legal parlance, it doesn't mean it's wrong. It doesn't mean it's illegal. I think what it means is really that, and correct me if I'm wrong, that the sort of, especially in the UK, where we're looking at a codified system where everything is, you know, written down, they haven't yet moved to the point where there are laws that talk directly to a foundation and how to treat it.
Yeah.
And therefore, they typically can be treated as a company. So same with the US. They're not saying, oh my God, you got a foundation, that's wrong, forget it. What they're saying is, well, our law doesn't actually specifically deal with foundations. So because it looks a bit more like a company, or it could be a trust, we're going to apply either the trust laws or the company law to it. And that's where, for example, when we're working with clients, setting up foundations, for example, who have UK beneficiaries or UK assets, because most of my clients, the older generation, are not UK based. We will talk to, Morag and I do a lot of work on making sure that the wording of a constitution document, and even not just the form, but even the substance, and explain to the client that the way this structure has to run to ensure that it fits either a trust or a company, depending on which one it's going to look like.
Yeah, and I think that's right. So when we say they don't recognize it, it doesn't mean that the structure doesn't exist. It's just because it comes from a different jurisdiction and civil law jurisdictions, we don't have the legislation, the case law, the codification around treating foundations separately. So what they do is they effectively fit, a square peg into a round hole and do a best fit exercise based on the legislation that they have. There's a number of different areas of taxation where that takes place as well, where they say, well, we don't really have that in our country, so how are we going to fix it? Rather than create new rules, we'll just do a best fit approach. So that lack of recognition isn't in terms of the structure itself, it still stands, but it's more an exercise that has to be carried out in order to ascertain how will it be taxed. And as Bimpe quite rightly said, I mean, more often than not, that conversation comes up because there are UK resident beneficiaries. So the structure might have worked completely tax efficiently, there was no issues, it's been running for 5, 10, however many years, but then you have a child who was educated in the UK who decides they want to stay in the UK. And all of a sudden, a structure that didn't have any exposure from a UK tax perspective needs to be looked at again, because whether it be distributions for ongoing higher education, or they're working in the business, or you are providing them with income to fund their lifestyle in the UK, all of a sudden this structure, which wasn't necessarily made with the UK legislation in mind, has to be stress tested with UK legislation in mind. And so that conversation is something that's important to have on a regular basis to ensure that as your family's needs become borderless and more global, the consequences of that document work in jurisdictions where that type of structure isn't as commonly recognized.
But as I said earlier, foundations are more newfangled. They really came about in Liechtenstein in 1926, in large part because of the state of the Liechtenstein economy after the First World War. They went heavily into finance, and Liechtenstein foundations were an enormous success, albeit amongst the more opaque and secretive structures, which of course was a major selling point. And then Panama in 1946 literally copied the Liechtenstein legislation and crossed out Liechtenstein and put Panama at the top. And so we had the growth of Panama foundations, many of which inadvertently featured in the Panama Papers, which didn't do Panama much good as a credible jurisdiction. But we have seen, as I say, a proliferation of jurisdictions creating foundations, I think because of the perceived advantages of a foundation having separate legal personality and frankly being better for holding certain types of assets. I want to come back to one key point. In any structure, you've got to look at who is responsible, who is accountable. The reason a trust works is because it's enforceable by the beneficiaries. So if you're a beneficiary of a trust, you don't like what the trustee is doing, or the trustee's made a mistake that has cost the trust fund, the beneficiary has always got the ability to go to the court and hold that trustee to account. And the trustee and the court will look at the situation and make a ruling requiring the trustee to recompense the trust fund if the case is made out. That is of fundamental importance. The beneficiary can enforce a trust. The key point with a foundation is it the same in the jurisdiction in which you're setting up a foundation? Because it is sometimes not the case, and as a result you might find a situation, as I found, where the patriarch had passed away and his children got no benefits at all out of the foundation and found themselves in a situation where they were really unable to challenge the conduct of the foundation's council, because that particular jurisdiction did not give them rights to information, because information is power, and it did not give them the forum to challenge the decisions of the foundation council. So that was an interesting case, because there were specific reasons why that jurisdiction and foundations had been chosen, but when the structure was put to the test, it didn't really work, did it? So I just wanted to ask, Lorna, do you sort of war game structures that IQEQ are putting in place and sort of stress test them to see whether they look to the future? I mean, Bimpe made a wonderful point, which I think is very relevant here, which is it's all very well for, for the father or mother to set up a trust, but unless they mention it to the children, you may have unhappy children, for example.
Coming back to the foundation, it's quite a recent law. For the trust as well, Mauritius as a jurisdiction compared to the Channel Islands are quite new in terms of the regulations with regards to trust and foundation. But the only thing that's an advantage of Mauritius is that we are both under the civil and the common law, which is an hybrid legal framework that we operate. So if there is no local precedence, the lawyers can always make precedents to other jurisdictions as the basis of the case under which they can formulate the argument at the level of Mauritius. But
so I was going to exactly that. Sorry, let me.
That's all right. But as to date, there has not been like any real case scenarios in our court environment that we can use as a precedence to what had happened or what are the measures that we can take.
No, I was just going to add to that, that in the case you're talking about, I think it's important in the modern day sort of well-structuring to consider these jurisdictions and the legal systems. And one reason why I do like Mauritius is that, like you said, it is, has that hybrid civil and common law, and therefore the sort of the fiduciary duties of the council are written into the Mauritius legislation itself. So that unlike, where, I don't know where this one happened, the beneficiaries have a better protection because is actually enshrined in the actual legislation that governs foundations.
Correct. Yes.
I think and just in the context of stress testing structures, I mean, this is something that I do for Bimpe and her clients quite regularly from a UK perspective. One of the common issues that arises in trusts, and I've seen this in my experience working with Jonathan as well, is a lot of information, and not just trusts actually, foundations, a lot of information sits within the head of the family. It sits within his right-hand man. It's not written down, they don't need to write it down. As the structures evolve over time, people move on, people have health concerns, people pass. And from an HMRC perspective, inquiries can happen where they're asking questions about scenarios and commercial decisions that are 6 years old, that are 20 years old. And so HMRC are a creature of documentation. You can tell them something, but they'll believe it if you show them something. And the best type of document is a contemporaneous document, or as close to contemporaneous as possible. Because the view they take is, well, it's all well and good you telling me now this was a commercial decision, but you don't have any documents from the relevant period that prove that that was a commercial decision. So we work with advisors, we work with trust companies, we work with fiduciary service providers to stress test those structures and say, well, what if someone comes knocking on the door? What types of documents, what types of assumptions are we relying upon that actually, if something happened, we don't have the documents for? And sometimes it's as simple as a board meeting minute, saying, well, we all sat down, we decided this was a very good commercial decision, but we want to take legal and tax advice on it. All of a sudden, you have a document which makes very clear, yes, of course, we're going to be sensible and pragmatic and take legal and tax advice, but it wasn't only tax that drove our decision-making. There were other factors within the business, within the family, which drove that decision-making. So sometimes stress testing isn't always kind of waiting for an attack and kind of firefighting at the time. I think there are key events that happen within the life cycle of a business and with a family which could prompt a very simple and a slightly more cost-efficient way of bolstering the structures from an attack, whether it be from a disgruntled family member or a business issue or a tax authority. So I think when we think about, stress testing and the solutions to mitigate, if we're doing it little and often and being pragmatic and telling our advisors what's going on, we're only as good as what you tell us. So if your right-hand man leaves and you don't tell us, we can't advise you on, well, what do we need to put in place to ensure that information is retained within the business?
That's actually why, for example, a foundation, is something I favor, because it's set up like a company, and like you just said, Jonathan, people are used to the ideas that at least there's corporate governance, or at least nowadays people take it more seriously. So, in any decision that's made, there will be minutes of a foundation council meeting. We run foundations and we insist that twice a year, we have meetings. Luckily, we can do it on Zoom these days, but there are minutes, and we keep records, and we, all the correspondence, and we say it not just for HMRC, but we also say, listen, you have beneficiaries who at one day may decide to challenge something that's been done by the council, and you want to be able to show them that, this was the thought process that went to it. It wasn't some sort of, unilateral decision, but that everybody came around the table, advisors were consulted, the minutes were made, they were taken, the resolutions were passed, and therefore there was some governance around how this wealth or, the shares in this family business in Nigeria are being sort of managed by the family's own entity.
Good. Well, I think we've probably arrived at the point for questions or Slidos, I think.
Yes, you have. And we're waiting. We're going to put the Slidos up, but then, as always, anyone in the audience who has questions to ask, all you need to do is indicate, and we'll get a microphone across to you. But in the meantime, you can engage with the Slidos, and let's see what your thought processes are. So in the meantime, which structure do you prefer? Everyone's saying a combination of both. Okay, but I kind of like, for me, I'm learning too, and I'm thinking, I'm not sure if it was Jonathan that said it, that trust is not legal, it's a relationship. So it means that, and you favor foundations over trust. Is it that we don't, around here, is it that we don't trust each other as we should when it comes to family wealth?
No, I think really the experience of trusts, and I think there are local trust companies in Nigeria that provide trust services. A trust is created by a trust deed, and that is usually the document that governs everything. And often the trust deed can't usually be granular in really laying out the patriarch's vision, their ethos, their family ethics, the rules of engagement. The trust deed can't do all that. So the patriarch, in the lifetime of the patriarch, it works because they're there telling everybody, you do this, you don't, you can't, talk to your brother like that, etc., or what have you. But when he's no longer there, that trust deed actually, and you have a letter, and he has a letter of wishes, which is a letter of wishes, but suddenly the trustees kind of find themselves in a position where they're very transactional about distributing money or assets, but really, it doesn't really help with any of the other things we've talked about that, is important for families of wealth to build a lasting legacy. So a trust really doesn't create that legacy. So I think a foundation gives the governance, gives the engagement, the communication, the ability to bring the next generation into this discussion around a family council meeting is one of the reasons why, I sort of would often recommend a foundation over a trust.
The room is reading a combination of both, but I have a question here. Sir, please go ahead. Do we have any other questions? And please, would appreciate if you rose or rise to ask your question so that we can get the pictures done right. I'm sorry. Going forward, just rise.
Thank you very much to all. My name is Benjamin Oviosu. I have the following questions, please. Is it advisable for assets to be bought in the name of the foundation or the protector's name? Is it advisable for the assets to be bought in the name of the foundation or the protector's name? And the second question would be, that are there restrictions to transfer funds from a personal account to a foundation account?
Well, I mean, dealing with the question about who buys the assets, I mean, ordinarily the foundation would buy the assets, although I suppose it would be super common for the foundation to incorporate an underlying holding company, and the holding company would then buy the assets. So you'd have a structure with a foundation, a holding company, and then the assets, or equally a trust with a holding company and the assets. And certainly a lot of trustees like that structure, because then you have the limited liability of the company. But it would be unusual for the protector to hold trust assets, because normally the protector is not in the game of holding assets. Rather, the protector is a watchdog, effectively looking over the key actions of the trust, or in the case of a foundation, you can have a guardian playing a similar role. So the object of the protector is typically to step in and blow the whistle if he doesn't like the way things are going. So normally the protector or guardian will be given consent powers. Normally the trustee says, I want to make a distribution to the child, and he has to get the consent of the protector, who double checks it. Or typically the protector will have the power to appoint and remove the trustees or members of the council, which is a key power, because if you've fallen out of your trustees, you want to have the ability to move them on and appoint more agreeable trustees, and that power is very often vested in the protector to exercise.
Okay, well, so we have questions that are already said. I hope your question has been answered, sir. Excellent. You have a question as well?
Did you answer the question about moving funds from, you asked a question
about moving funds
from a personal account to a foundation account. I think you asked that question. I would say what that means, if you're doing that, it means that you're actually adding assets. So the foundation is set up usually with some assets, and there's always, within the charter, there is an objective to continue to accumulate, or, so basically what you're doing is handing over the assets to the foundation when you're doing that sort of, and the foundation has to pass a resolution and will want some compliance over the source of funds before it accepts the funds into the foundation account.
Thank you. We have the questions on the screen right now. And while you're reading that, you have one question to ask. And it's not any of these ones that you have up here. Okay, ma'am, go ahead.
Okay, hi. I think my question is probably to Bimpe or anyone else. I didn't really hear much around these jurisdictions for the setup of foundations or trusts. Just to explain more about, local jurisdiction versus offshore, and then the offshore options, which would you normally recommend when you're setting up the structures?
So your question is?
Jurisdiction. So are you setting up locally or offshore? And if it's offshore, what region would you normally recommend?
If it's, to be honest, I think locally, meaning in Nigeria, often structures, I think, trust is what would happen. I don't think you have any capacity here yet to actually handle what the foundation structures we're talking about. So I think in Nigeria, typically I see Nigerian trusts settled in Nigeria to hold assets in Nigeria. Definitely, that happens. But you can also use structures from outside Nigeria. So that Mauritius Foundation or Jersey Trust or Jersey Foundation or Cayman, a myriad of jurisdictions can also hold assets in Nigeria. And like Jonathan said, is usually, and this is what I also structure, is that the Nigerian assets should be held by a Nigerian company, and then the shares in the Nigerian company can be held by that foundation or trust. Because definitely, the fiduciary companies in Mauritius or Jersey want to limit a bit of the risk of exposure, because at least they're holding shares. They're not holding the assets itself, and they don't live here. They don't, understand or really want to get involved in the day-to-day of the house or the company or what have you. But if it's shares that they're holding, and there is a board structure around in the company, there's corporate governance in that Nigerian company, it also helps them feel that they have oversight from Mauritius or Jersey, or rather than having to be involved in the nitty-gritty, if that helps.
Thank you. I have one more floor question, ma'am. Please, could you rise?
No, I was just going to add to Bimpe's comment, like in terms of jurisdiction, It will be really like the Singapore, Mauritius, Isle of Man, Jersey, Guernsey, Cayman, but it all falls like what is the requirements of the client, like in terms of proximity, in terms of, you know, your presence of your wealth managers and all your stakeholders. So this is where the trusted advisor also comes in, not only to pinpoint on one jurisdiction, but really go through that, maybe that stress test to say, like, what are your future objectives of the foundation or the trust, and then match the jurisdiction with the requirement to ensure that you have the right vehicle for the years to come.
There's also tax considerations also.
Very
because
much.
If the beneficiaries are, you know, potentially are US persons, maybe their children or grandchildren, then you're probably looking at maybe even having an onshore US trust that might work better for. So there's a lot of considerations.
And I think as well, when you're thinking about picking trustees, you know, again, it is a relationship based on trust. You have a lot of professional trustees, but you have choice. You know, you can ask them the types of questions that you need answered to provide you with the comfort that these are the right trustees for you. Some people want, you know, dynamic trustees who are interested in, you know, innovative investments and decisions. Some people want a more traditional trust structure. Some people want the trustees to take a pastoral role and educate the beneficiaries around the wealth and various different things. So, you know, there's a selection process that the settlor can have some control over. But there is a lot of choice, and there are a lot of jurisdictions that have been doing this for a long time, mainly in the jurisdictions that Lorna's mentioned.
Which is just touching very briefly on that, and again, harking back to Barclays, where I was on the management committee of the international trust businesses. With the benefit of that experience, I always say to my clients, you've got to make sure you're dealing with a profitable business, which is not, sounds obvious, because I mean, after all, who wants to deal with an unprofitable business? But I always check that the business is making a profit, because then they're likely to do a better job. But the other thing is, it's just like any other business. So in the same way that I'm a senior partner in a law firm, we have junior lawyers, and I pass some of the work down to them. I always try to understand who is doing the work and who is in the line of succession, because that is really important. I normally encourage my settlor to visit the jurisdiction that we're going to be working with, because just going there gives an enormous depth of knowledge.
Just looking at the questions.
We have one from the floor who should stand by to ask a question. Thank you.
Thank you. My first question is, what's the difference, essentially what's the difference between a foundation and a family office? That's one. Secondly, where a client has assets in multiple jurisdictions, what's the best structure to recommend for that client? Thank you.
I think it's part of all these questions, so you guys just
Okay.
go with this.
So I'll take the foundation and family office. And in fact, I said in the panel before that what I run is a wealth management company that's akin to a multi-family office. So in onboarding clients, one of the things we do is we do some wealth structuring, and we say to them, let's look at the best way to hold the wealth, family wealth, and usually it is through that entity that is an overarching entity, usually a foundation. There's something called a private trust company that's also possible, especially where it's most jurisdictional. But basically, that entity, especially when it's a foundation or a PTC, becomes your family office. It can become your family office because the governance documents, the foundation charter that you're creating, and the regulations that talk about distribution and behavior and ethics and even succession lines, basically become the family office's handbook. And again, around the table of that foundation structure, you can have your asset manager it doesn't have to be a member of the council, but you can have an investment advisor, you can have a governance advisor, you can have a trusted advisor, either as members of the council or sitting in parallel. So literally, that foundation becomes both an asset holding structure for asset protection and estate planning, but the documentation that we create then becomes the working sort of documents for the family office, if that helps. I've talked about the fact that you can't put a governance structure in a trust because the trust deed, there's a limit to what a trust deed can really accommodate.
I just wanted to, one of the questions is, some people are struggling with the difference between a trust and a foundation. So I just wanted to go over that again. They are just different types of ways in which assets can be held. So a trust effectively splits out the ownership of an asset. So every asset has both a legal owner, so the person whose name legally owns the asset, and the beneficial owner, which is the person who receives the benefit from an asset. So you may have a property where on the deeds, somebody's name is on the deeds, but actually the rental income is being received by somebody else. A lot of the time they're held by the same person, but it is possible to split the legal and the beneficial ownership. Where you have a trust structure, you are consciously deciding to split the legal and the beneficial ownership of an asset. And you are entrusting the trustees to manage that asset in a way that the asset is managed in the best interests of the beneficiaries. So the trustee is duty-bound when making decisions to ask themselves, is this decision in the best interest of the beneficiaries? And so if it's not, then they cannot take that decision. But ultimately, it's a combination of wanting to look at the ongoing growth of assets. It can also be an asset protection issue. So some people don't want things in their personal name. They would rather have a third party holding assets and managing them for them. Conversely, a foundation is a legal construct. It is an entity. The foundation is the entity, like a company. And effectively what you do is you transfer the assets and the decision-making to the foundation. So you're not necessarily splitting up the legal and the beneficial ownership. You're saying, I would like my assets held by a foundation, and there are various governance and constitutional options within a foundation that allow the patriarch to retain control over how the assets are run and be part of that decision-making in a way that when you give your assets over by way of trust, you lose that right. So it's not about what does the settlor want, the person who settled the trust. It's about what do the trustees think is in the best interest of the beneficiaries. And so there may be divergence between what the trustees decide and what the settlor ultimately wanted. And so it's that element of control which causes people to think about what is the right structure for them. And that's why when I think someone was asking about kind of the governance of a trust relationship, there's only so much governance that a settlor can put in place when ultimately they've given up the rights and responsibilities to someone else. So you have to be comfortable with an element of loss of control with a trust, but it has benefits in terms of ensuring those assets are run in a way that's not just for the benefit of the patriarch or the settlor, but actually future classes, which could be children, grandchildren, spouses, charitable needs. You know, you can choose who you want to benefit from the trust, but you cannot make decisions as to how that benefit actually is borne out outside of the confines of the trust deed, which is, as Bimpe has said, can be for some people too restrictive in terms of their control. I hope that's been helpful to whoever asked that question.
Maybe I'll go the first questions, like can the beneficiaries be on the council? So essentially that's an advantage of using the foundation, is that the beneficiaries can also be part of the council members. And how soon you want to bring them on board is really how you feel they are ready for taking those decision making. But I think that's a little bit an advantage of the structure, that you empower them at an earlier stage to be part of the founder council members, to grow into the business, to get involved into the business, to be engaged, and finally to take the relevant decision ultimately to ensure that the performance of the foundation and the underlying company continues. So yes, and the earlier you can bring them on board, the better, but it also gives you the power to decide when to do it.
Jonathan, do you want to take the question about 7 years?
Yeah, well, I'll try. Yeah, with this 7-year period, I think is a bit fabled because it links in, I think, to inheritance tax, where in the context of Nigeria, where hopefully people aren't long-term UK residents, as we're now focused on following the abolition of the non-domicile regime, suppose you've got a UK asset, you've got an inheritance tax problem if you die. One way to avoid that is to give the asset away to a child or someone else and then survive for 7 years. It's called a potentially exempt transfer, and it's still relevant, notwithstanding the recent changes that the government made in the last budget. I mean, in the context of trusts, I'm not aware that the 7-year period is relevant, although it would be if I had set up a trust, because I'm a UK domiciliary and not a non-domiciliary. But I think what we're seeing now with trust, and I think it's a fundamentally important point, we've moved away from the era where trusts were driven by purely tax-related reasons. That is really, yes, they can have tax advantages, but I'm not sure I would encourage anyone to set up a trust just because it was delivering a tax advantage. I think the biggest advantages of trusts are, as one of my clients put it to me last year, she said, I want to have a trust because it is the best vehicle for holding and managing my wealth. And of course I found that very encouraging, but one of the reasons she said that was that the trust resolved her succession planning issue because she didn't need to worry about probate if she died, and her assets were then held for her young children by well-appointed trustees on long-term trusts for their benefit. And that, I think, is really a fundamental importance. It's about succession planning and estate planning. And with that client, of course, there were tax-related issues because she was resident in the UK, so we had to cover that to make it work from a tax perspective. But it's not driven purely by tax anymore.
I think that's a really important point. If you don't own the asset anymore, or you're not the beneficial owner of the asset anymore, it doesn't sit in your estate. So from an inheritance tax perspective, and when you're thinking about the pros and cons of different structures, when you're dealing with a foundation, if the founder still retains some control, again, looking at it purely through a UK lens, then there's an argument that he still retains some of the benefit. And then there's a debate about, you've got to look at the constitutional documents to see whether or not it's still within his estate. And as I scared many of you with yesterday, IHT in the UK is 40%, or if it's in a separate structure. So it's not, as Lorna said at the outset, it's not a one-size-fits-all. It really depends on which jurisdiction the assets are in, and it really depends on your goals for future legacy and succession planning. There's a question about how do distributions to beneficiaries in a foundation differ from distributions in a trust. Depends if you're the settler of a trust or if you're the founder. There's very specific rules if you're the one that set it up and you still retain an interest. But for beneficiaries, ultimately, it depends on where you're tax resident and where you receive that income. So you need to make sure that each of the beneficiaries receives independent advice as to how that income is treated in the relevant jurisdiction.
Yeah, no, I mean, that is just worth touching on because the other day I came across a classic. It was a reserve power trust set up by a person here who gratifyingly is still alive, so everything's still going well. But then he revealed his children were in jurisdictions such as the United States of America, the UK. One was building a career here in Nigeria. Another one had gone to Canada. So I had to highlight the need. We really should be getting tax advice in those jurisdictions to work out how do those jurisdictions' tax systems fit with his children being in America, Canada, Nigeria, and the UK, because suffice to say, they all have subtly different rules. It is possible, by arbitrating the cross-border tax issues, to arrive at a satisfactory conclusion, but it is only possible if the issues are clearly understood.
We've been asked a question about family investment companies. Are they different from normal companies? Yes and no. They are companies, so there's not a kind of uncertainty in the same way foundations are. but the way in which you set up that company by way of articles of association, shareholders agreements, etc., are very tailored to the investment needs of that family. And so it's quite a very specific process to set up a family investment company. I will also say HMRC do not love family investment companies. There was a targeted review of family investment companies, and that was closed, and they realized actually they are legitimate companies, albeit for a smaller class of people and shareholders. But again, it's just important to ensure that the documents you put in place actually reflect the reality of what you want to put in place. But it's not an uncertain structure. It's a company defined for specific investment decisions and needs for the family. And you can have within your wealth planning structure, and this is where an advisor like Bimpe is invaluable, you can have multiple structures within your wealth management succession planning structure. You know, that's where the advice really becomes super important, because some people have a combination of foundations in certain jurisdictions in respect of certain assets. They have trusts or, you know, legacy trusts that are still generating benefit for beneficiaries. You may want a family investment company in the UK for, you know, beneficiaries who are based there, and you want them to make decisions in respect of a pool of assets or income there. You know, it's really looking at that 360 holistic view of what is right for your family and your family business interests, rather than just saying, well, someone said, let's get a trust and I'll get a trust. Because once you're in a structure, more often than not, if it's not the right structure for you and you have to unwind it, there are usually cost implications and tax implications for doing so. So I'd say be proactive with getting the advice before you start setting things up. I've had a number of clients who come to us and they say, well, I've already registered the company and I'm ready to go. And that means they've triggered filing obligations in the UK with Companies House, et cetera, without understanding the implications of that.
If you don't mind, it's lunchtime, but I think our guests are sneaking in this question instead of coming to meet you privately. So they should interact with you at lunch and ask. But I think the last one, the one that says what happens when a settler passes on, I think I'll let you guys take on that question, and then we'll round up this session and go for lunch.
Okay, thank you. In a foundation, what happens when a settler passes on? Well, you'd say founder, and a settler is a trust. But basically, the whole idea of setting up a trust or a foundation is that the plans and the wishes will outlive without having to write a will. First of all, there's asset protection, there's tax efficiency in that structure, because sometimes you don't have to go through probate if it's a trust, for example. So the reason for setting that up is actually for that founder to know that after his lifetime, his family will still continue to use this structure for their benefit. And actually in a foundation, for example, the founder is there. He may or may not be the protector, but if he's a protector, we've put something in, some provisions in the foundation charter that actually say who takes place, who substitutes on the passing of protector, who becomes the next protector. And you can then say someone from the next generation can step into the shoes of the protector who has sort of the overarching sort of interest to make sure things get done. You can say, when beneficiaries who are 25 or 30 and older, become or adults, they can join the council. So that foundation can actually be used almost in perpetuity, because the foundation charter lets you, change and substitute and allows the next generation to come into place. And so just sort of passing the baton on and on and on. And that's actually what a foundation is very good for.
Thank you very much. I think Jonathan is going to round up now, and then we're going to take photographs.
Well, thank you for listening. It's, I think, a wide-ranging and hopefully sometimes incisive look at this issue about trusts and foundations. Just in conclusion, my observation is that foundations have come up very hard on the heel of trusts. There were some fantastic questions. One was civil law versus common law. I've got no doubt that foundations have evolved enormously over the last 20 years or so. I mean, in closing, just to mention for anyone who's interested in the subject, you could look at the explosion of DIFC foundations, which were initially really born as creatures to hold UAE real estate. But now we're seeing them applied to holding highly sophisticated UAE businesses in a way that one would normally have gone to a trust. So it is an evolving world. Last point, substance. Whatever you want to do, it's got to be well thought out and properly run.
Thank you very much.